Thank you, and welcome back to News Humor. This is actually being made for my series on the Constitution, talking about how the Constitution reads. And I started looking into it, thinking about doing a video about Trump and why Congress didn't go to the Supreme Court right off the bat when he didn't answer the subpoena. And so I started looking into MARBURY versus Madison, because I'm pretty sure that's the one I was talking about when I was talking about the Constitution and how the Supreme Court works. Anyways, I really started looking into this, and it is absolutely insane, some of the stuff that's going on here. I felt like I had to share it. So even though it's not the video I wanted to make, it's the video I'm gonna make. I don't wear black all the time. It's just a special occasion. Let's get right into it. I got a good program set up for y'all this evening, and I hope you enjoy it. We're going to go through and watch some C-SPAN interviews about MARBURY versus Madison and see what's going on here, to see if we can figure this out and whether the Supreme Court is for upper-level governmental officers as original jurisdiction, as I was interpreting from public ministers. Let's check it out.
Adams appointee John Marshall as the Chief Justice in the case, but he and Jefferson also have a personal family relationship and are political enemies.
So they are second cousins, and they don't much like each other. John Marshall is a nationalist. He was there at Valley Forge with General Washington in the Revolutionary War, and that Army experience really predisposed him to be very much a believer in the central government. Thomas Jefferson's more of a states' rights guy. And remember, Marshall himself maybe was putting himself forward as a possible presidential alternative if there was a deadlock between Jefferson and Burr. Marshall is the most popular Federalist. John Adams is no longer very popular. He's been repudiated, but John Marshall is actually the leader, in effect, of the Federalist Party, so there's all that politics. And there's some personality there. As I said, second cousins from Virginia. They're both connected to the Randolph clan. Marshall's mother-in-law was the former fiance, or had been courted at least by Jefferson, and there was some bad blood there. So there's that whole overlay on top of that. But then remember one final thing. It's Marshall himself who, as Secretary of State, in effect, fails to effectuate the delivery of these things. Now he's, as Chief Justice, hearing a lawsuit about that factual transaction, as to which he's, in effect, a witness. And the Supreme Court is sitting as a trial court in what's called original jurisdiction. So there really is a question, truthfully, at least by today's standards, of whether John Marshall should be hearing this case at all, or whether he shouldn't just recuse himself. Not because he's a Federalist, because everyone's a Federalist or a Republican. You're going to be on one side or the other. Not because he's friends with Adams, because everyone's friends with everyone else. But he is a witness to the very transaction involved, and yet he has shown no indication whatsoever that he needs to bow out of this. He's threatening, at least in the early stages, to issue this order to his successor, Madison, and his rival, Jefferson.
John Marshall's home was Richmond, Virginia. We traveled there with our cameras, and next you're going to see a little bit of his home and how they interpret it for today's visitors.
Okay, so that's really interesting, because John Marshall is exercising original jurisdiction in the Supreme Court, and he's a Federalist. I don't know how many of y'all know this, but the Federalists and the Republicans were kind of like the Democrats and Republicans of their day. So the Federalists were the people who wanted to see big government. They wanted to see the federal government expand, have more control over the states, and get bigger. The Federalists, okay? And the Republicans, they wish to be left alone, exercise their own Republican form of government, have freedoms, not have this big invasive government getting in the way of every decision they make. Thomas Jefferson is a Republican, and Marbury is a Federalist. What happened was John Adams, as he's going out the door, assigns a bunch of Federalists to two different courts, various courts, because he is the executive branch of government. He has the right to do that as long as he does it before he gets out of office. Okay. This is absolutely insane. Jefferson was courting John Marshall's mother-in-law. And they don't really like each other. They have two different ideas on how the federal government should be run. Jefferson believes that the states should just run themselves, keep the federal government out of it, let people do what people are going to do, because, we're responsible enough to do that. Marshall, on the other hand, thinks, well, maybe they're not responsible enough to do that. People need to be governed, and we should be the ones governing them. So you got two conflicting ideas here, and it sounds like you got a lot of family, personal stuff going on. This is an interesting case, the way it's shaping up. Let's see what comes up next. I don't know where this is going to go.
When was it heard?
Initially there was this proceeding in December 1801, and then it is heard again in February 1803, the next stage of the case.
And it was heard in that courtroom you described in the Capitol building.
Yes, exactly.
The dank lower level court.
Yes.
And it was conducted the way that we hear cases today, as oral argument, or something else?
No, it was very different because it was an original action. Marbury had filed suit in the Supreme Court under a part of the Judiciary Act that he said, I can file an original action asking the Supreme Court for mandamus. And so basically the Supreme Court had to have a trial to establish the facts. So they had to have witnesses. And so Marbury's lawyer, Charles Lee, the former Attorney General, puts on witnesses. Now, he has a bit of a problem because the witnesses work for the government and they're suing the government. There are these two clerks at the State Department. Well, they work for James Madison, but he puts them on as witnesses. They're very reluctant to testify. They object. They think they shouldn't have to testify about the inner workings of the executive branch. And John Marshall makes a series of very careful rulings. They can testify about the facts of were there a commission, but they can't get into internal deliberations. But there is basically an original trial going on in the Supreme Court. But there's one very unusual fact about this trial, which is that the defendant, James Madison, Thomas Jefferson, they refuse to participate in it at all. They're showing total disdain for it. The Attorney General, Jefferson's Attorney General, Levi Lincoln, and he had done this in December 1801 also, he's in the courtroom, but when he's called upon by John Marshall, he refuses to participate as a lawyer in the trial at all, or to make any arguments. They're not going to dignify it by doing that. But as the trial proceeds in February 1803, they actually call him as a witness to testify about whether he knows what happened to these commissions. And he very strenuously objects on various grounds to testifying. And again, John Marshall makes a series of very careful rulings, but very different from what you would see in the Supreme Court courtroom today.
Okay. Again, they talk about original jurisdiction, original writ, original action, the original trial, original. Witnesses object. Okay, so I'm sure that they were subpoenaed, which means that they were commanded to come into court and testify. Levi Lincoln thought it was an absolute charade. Refused. And they still pulled him in. He was an attorney. And remember, everybody who's doing this, everybody who's in this situation is an attorney, is a president, is a Secretary of State, is part of the legislature or was part of the legislature, was a president. All of these people, incredibly immersed in government. Most of them helped create the Constitution, interpreted it, put it together, worked with each other on it. And this is what's happening. They're getting dragged into court. They're suing one another. It's like a family trust gone bad. Let's see what happens next.
When the Chief Justice delivers the opinion, the case is boiled down to three central questions. The first was, did Marbury have a right to his commission? The court said what?
Yes, he did have a right to his commission.
Question two, if he had a right and the right was violated, did the law provide a remedy for him?
Yes, he did. And on both of these questions, Marshall is very clear that he thinks that the Jefferson administration and Jefferson have acted against the law, that they were duty-bound to give them the commissions once they were duly appointed. And so it's actually the harshest criticism of a presidential administration in a Supreme Court opinion up until that point.
And question number three, and here's the part where everyone looks to the thinking of the Chief Justice. Point three, if the law provided a remedy, was the proper remedy this mandamus or direct order from the Supreme Court? And it was on this point number three, John Marshall decided what, in this case, became historic.
So remember, we're taking Marshall's ordering of the issues. You know, from a proper point of view, here's the first issue in the case. Can John Marshall sit? The answer is no, he should have recused himself. He's a witness with first-hand knowledge of adjudicative fact. The second issue in the case is, does a court have jurisdiction? Does it have the power to even hear the case? Because if it doesn't have jurisdiction, it's a bunch of people in black or other colored robes telling other folks what to do without authority. So from a modern point of view, John Marshall, inverted everything. Why? In order to score a bunch of political points against Jefferson in some ways. At the end of the day, he's going to pull back. And at the end of the day, he's going to say, even though what Jefferson and Madison have done is totally illegal in all these ways, at the end of the day, he says, actually, it turns out we don't have jurisdiction. And we don't have jurisdiction because this congressional statute that could be read as giving us jurisdiction is actually unconstitutional, and our job is to give effect to the Constitution, even if that's at the expense of a congressional statute. Now,
what? What? Are you kidding me? We went through this whole court. We went through this whole trial just to find out at the end that we didn't have jurisdiction. You mean you didn't know you didn't have jurisdiction when you started this thing? You mean Levi Lincoln and all the other witnesses from the government of the United States who didn't want to show up, who didn't want to testify, who didn't want to participate in the trial, somehow you ordered them to do that, and you didn't even have jurisdiction? And you're a Supreme Court justice. You're the man who's deciding what goes on in the Supreme Court. You got a lot of heavy influence. People think that you know law. They're looking to you to know law. And you don't even know if you have jurisdiction or not the whole way through the trial. It's not even the first thing that you address in the case law. I read the whole case because I was under the impression you had jurisdiction. If you didn't have jurisdiction, why didn't you just say that? Why didn't you just come out from the beginning? I mean, all of y'all are attorneys. Half of y'all helped put together the Constitution. You sat in the legislatures. You operate courts. And you don't know if you have jurisdiction or not throughout the whole trial. Okay, I'm done. But see, here's the thing, is that this case is the case that determines that the Supreme Court of the United States can determine what's constitutional and what's not constitutional. And so that gives rise to a whole new appellate jurisdiction and how it operates. And it gives rise to being able to move from the common law over to case law and start convincing attorneys that case law is what common law is. Because common law is more like natural law from what the founding fathers wrote about. And that's the law that you can get to through reason alone. You don't have to be an attorney to know what natural law is or natural rights is. How come if somebody comes and rips you off for $3,000, $4,000, and you want to go after them, oh, you got to go get an attorney. So you got to pay an attorney $7,000 to go down to the court and say, that man did me wrong? What kind of sense does that make? That is absolutely insane. That is absolutely insane. I've been in court so many times where the judge is saying that they don't understand the individual in court. You're going to see some more of that with the cases coming up that I'm going to report on. But, I mean, sorry, Mr. Judicial Officer, you went to law school. You passed law school. Not only did you pass law school, but you became a judge. Why should I have to pay an attorney thousands of dollars to tell you the difference between right and wrong? That doesn't make any sense to me. It's a little insane. It's a little kooky. Anyways, let's see what he has to say, because, it's not just my opinion that judges have the right and have the ability written right into the Constitution to determine in their courtroom whether a law is constitutional or not. So we didn't even need MARBURY versus Madison. I don't see why it happened. I don't see why it was ever recorded if the court didn't have jurisdiction and it was a trial court. I mean, obviously it was a court of record. That's how they were functioning. But let's see how we know that they already knew about judicial review. Let's just check it out.
What we talked about earlier, judicial review. It doesn't try to prove that judicial review is in the Constitution. Actually, lots of people thought it was in it. And remember, judicial review is the ability not just of the Supreme Court, but of any court, even a state court, lower federal court, to disregard a law, a state law, or even an act of Congress if, in the judge's view, that law is inconsistent with the Constitution. And in Federalist 78, Hamilton says, yes, it's in the Constitution, and that's a reason to vote for it, because that's a good thing.
Wow. Did you hear that? In the Federalist Papers, everybody knew back then that any judge, it wasn't just the Supreme Court, any judge could decide that some law, some state statute was unconstitutional, and they didn't have to follow it. But since they made this decision, MARBURY versus Madison, now they have this hierarchy, right? So it's like, well, it's only unconstitutional if the Supreme Court declares it unconstitutional. Yeah, of course your judges can have a little bit of leeway and they can throw out a case every now and then, but your main system, your federal system, the way it's going to work from coast to coast, when America finds California, is going to be the Supreme Court. You got this one court that makes all these big decisions, and all these lower courts, all the way down to the state magistrate court, is going to have to follow these decisions. It's brilliant. How do we get people to just fall in line? We tell them that we're going to make a case that says the Supreme Court, capital S, can make these decisions.
3:13.
Alright, so what should people do at 3:13 a.m.?
Leave a like, subscribe, click that bell to never miss another video. Leave a like, subscribe, click that bell to never miss another video, and share the video because YouTube's algorithms want your only hope.
Alright, go get back in bed.